Can the IRS really take your house or your bank account? The answer is, unfortunately, yes, they can. However, in this video, I'm going to explain when that's possible, when it's very unlikely, and what hoops the IRS has to jump through before they can do those things. So I want to explain real basically, real briefly, the difference between the phrases tax lien and tax levy. A tax lien is a notice filed typically in your county clerk's office, which attaches to your property, all of your property, real and personal, wherever it may be. As a practical matter, what it does is it attaches to your real estate, and you can't sell that real estate without satisfying the lien. That's the easiest example to understand. It's also public notice to the world that you have the tax debt and that you have the liability. It no longer impacts your credit score, and it no longer ends up on your credit report. So that's a good thing. That's as of 2015. A levy is a seizure. And that means it's also another word for that would be a garnishment. We know about wage garnishments if you don't pay child support and that kind of thing. The IRS actually can garnish your wages and or your bank account. They can also seize, levy other items, including cars, real estate, and things of that nature. When are they likely, or when can they issue a levy? The IRS has to issue you a final notice of intent to levy. It comes certified mail to your last known address. So if you're the type of person that moves around a lot, you may not get the levy notice. If you've been at your home for 10 years and you've been filing tax returns all along and they know what your address is, it's pretty likely you're going to get the final notice of intent to levy because it's going to show up certified mail and you're going to have to sign for it. That brings up another thing that I wanted to tell you about, and that most people that I represent actually have jobs. And so when the mailman comes, they're not there. And so they leave a little orange slip in the mailbox that says, come on down to the post office and pick up your mail. I know it's scary. I know it's frightening, but you need to go down and pick up your mail, because if you don't pick it up, you don't know what the letter is about. And if you don't pick it up, you can't give it to me. And I can't tell you what we need to do. So I would encourage you to pick up your mail. After you get the final notice of intent to levy, and that can be one of three letters, a CP90, a letter 1058, and the other letter is actually escaping me right now. So we'll go with, it just has to say final notice of intent to levy. It's actually not a CP504. If you have a CP504, that is not a final notice of intent to levy. So if you get the final notice, you have 30 days to appeal. Typically, we would appeal. While the appeal is pending, the IRS cannot levy you. If it's been at least 45 days, the IRS can levy your wages and they can levy your bank account. If you're interested to know how much money you're allowed to keep if they levy your wages, you can take a look at publication 1494. It's not very much. And so you're going to want to get the levies off of you as soon as possible. A bank levy varies from a wage levy in that a bank levy is a one-time levy. They're only entitled to the money in the bank account on the day the levy is processed. And then the bank holds the money for 21 days to allow the taxpayer to dispute it. And then if the taxpayer is unsuccessful, then they send the money that was in there on day one to the IRS, and it's gone pretty much forever. A wage levy is continuous, which means it continues until it's released or the liability is paid. Neither one is very good. If you have other questions about this or really anything else pertaining to IRS tax resolution issues, I suggest that you visit our website at getirshelp.com.